Ms. Simmons. Please state your name and who you represent, and we look forward to your testimony.
Thank you, Mr. Chairman, members of the committee. My name is Kimberly Simmons. I'm the Executive Director of the Public Defense Commission. As I say that, you may wonder why I was not giving the presentation today. That's a really long story that you probably don't really care to hear at this moment, but I am here today. I was going to be presenting to the Senate Judiciary and Rules Committee on information about the Public Defense Commission today, and I decided to stick around and answer some of these tough questions. I think we're certainly in a rough spot. The ACLU and the Public Defense Commission, our end goal is exactly the same. We want to improve the public defense system here in Idaho. What I would like to do is give you a little bit of testimony as to why I think you should approve our rule today. Answer maybe some of the tough questions that Ms. Jennings, she addressed all of the comments and questions, I think, very appropriately. I think there were some questions that may have left confusing or unanswered that I'd like to address. And then I do have a statement from the chairman of our commission who was unable to make it due to weather that I would like to read to the members, if that's okay, Mr. Chairman.
Please proceed as you see fit.
Thank you. So I think you should approve our rules because rejecting them does more harm than good. Approving the rules does not harm our system. It only improves the system. So the main comments as I see from the ACLU today is really concerned around that caseload standard. Let me address that one at the very end of my comments here, because I think that is the tough question. What I don't want you to forget is that there are other standards in this document, our Section 7 standards here, that are certainly mandatory and would certainly improve the representation of indigent defendants in Idaho. Let's talk about that initial appearance piece. In many of our counties right now, indigent defendants are going unrepresented at that initial appearance, that first time after they're arrested and placed in front of a judge. They stand there alone. And a judge says, here's your charges, I'm gonna set your bond. And then they go away. Maybe they get an attorney appointed, but there's not an attorney there to represent their interests. What this initial appearance piece does is requires the county to make sure that there is a defending attorney available to make that argument. And so I would really hate to see that rejected this year. That is something that will cost the county some money. Some counties, as Ms. Jennings indicated, don't have a defending attorney in their county. Custer County, for instance, their defending attorney lives 2.5 hours away. So Custer County is going to have to get creative, perhaps set up some sort of video technology service so that the defending attorney can appear. We've also talked to them about some creative ways to have the defendant be able to contact that attorney prior to the hearing, get that bond information so that they can be represented appropriately, effectively, and constitutionally at that hearing. Let's not forget the vertical representation piece. It's important to our clients to have one attorney represent them throughout the entire case. And so that piece would be gone if this rule was rejected. Now, that is already occurring in many of the counties. Some counties like Ada County are going to have some difficult challenges in meeting that obligation, but I think we can get that figured out. The other piece is the training requirement. Defending attorneys will now have to get 7 CLEs per year in indigent defense issues. That includes not only criminal cases, child protection, immigration law, juvenile law, things that are very complicated. There is also the piece about getting the 3 hours in those specialized areas that I just mentioned, as well as termination of parental rights and guardianship cases, civil contempt cases, and then cases that involve significant mental health or competency issues. If this rule is rejected, that piece goes away, and our defending attorneys are not going to be required to get that training. Those things that I've just talked about were mentioned not only in the NLADA study as being a priority for Idaho and as being specific deficiencies that Idaho had, but also mentioned in the ACLU lawsuit. So I would respectfully request that you consider approving this rule so that those things are in place for our attorneys. I think the timeline is really important here, because if the legislature approves this rule this year, they'll be in effect of May 1. Compliance will be required by March of 2018. If they're rejected, we've got to wait until March of 2019 until these rules would need to be in compliance. The caseload piece was definitely a struggle. we put in the national standards, I think. And to answer the question, the national standard is 150 felonies per defending attorney a year, 400 misdemeanors per attorney per year, 200 juvenile cases per attorney per year, and 200 mental health commitment cases. We had initially had some other numbers in there that were not a national number. To be honest, I as a public defender of 13 years, I sort of pulled them out of the air and put them in there thinking, I think this sounds good. And we talked about it with other public defenders as well. And, there was comments on both sides, whether it was high or low. Ultimately, we decided to pull the caseload standard out, and I think you've heard a lot of testimony as to why. It is really important to get that Idaho data this year. It's not that the counties have necessarily been or have been not cooperating. It's that everybody does their system differently. And this was one of the reasons why the Public Defense Commission was created, so we could have some oversight to have more of a uniform system. But it's important for the counties to be counting their cases uniformly throughout the state, and that's not currently done. And so it was really hard to get good Idaho data. We have some. But I think this workload study is going to certainly get us some data that's unique to Idaho, uniform throughout our state, and will inform that caseload standard. Now, the language that you see in Section 3 there in your standards document, that all accompanied that specific number. And so the language in there is a little bit more permissive than mandatory as some of the rest of the rule. And the reason for that is because without a number, it's really hard to say shall. It's really hard to tell a defending attorney, you shall make sure that your caseload is not excessive, because they don't have a guiding number. But I think taking this out of the rule this year would actually hurt, because it gives the defending attorneys what the kinds of things we're going to be looking for. If you've got a problem-solving court caseload, you need to make sure the rest of your caseload is less than other attorneys. If you've got a capital case, a death penalty case, then the rest of your caseload should also be lowered. Those kinds of things. It starts to give them guidance so that when we do put in numbers, we're not just pulling something out of thin air and starting from scratch. It gives them guidance as we go forward. And so I do think it's very important that this rule is approved this year so that we can start somewhere, start phasing these in, and get the counties and the defending attorneys used to complying, and also assess what this is going to cost the counties. Because that initial appearance piece is going to cost the counties some money this year, we took that into consideration. Because I think there is, without a doubt, that a caseload standard is going to cost them additional money. I think it'll be important over the next several months, while we're doing the workload study, while we're implementing standards, if you so choose to approve, that we can assess their budgets and see where this is taking them. A few of the questions I think that were challenging, and I could maybe address to the members. There was a question regarding who is going to assess the performance and the qualifications of the attorneys. I do think in institutional offices in our state, of which we have 10, the supervising attorneys can sort of handle that, but they'll still report to our commission. We're going to be the ones having to do that legwork. And so we're going to have to assess whether or not they're meeting these standards. Also, these are not standards for ineffective assistance of counsel. I believe there was a question, it was either Representative McDonald or Representative Nate, about how this goes in the court system, that defendants would take these standards and run off to the courts and say, my attorney didn't do this. If you take a look at our statute, and I apologize, I don't know the exact section, but even in the standards document, it talks about how these are not a set, clear standard for ineffective assistance of counsel. These are guiding for our attorneys. They're guiding for the counties to see what constitutional representation looks like. But they're not supposed to be a basis, and they're not a basis for a court challenge for ineffective assistance of counsel. I think those were the tough questions, and if there were additional questions, I can leave that for the end. I just would like to read a statement from Chair Darrell Bowles. He's our representative on the commission from the Idaho Juvenile Justice Commission, and as I stated, he wasn't able to make it due to weather. Everyone can agree that indigent defense Idaho needs improving. That is and will continue to be the focus of the Public Defense Commission. The commission has been working hard on improving the system. Please remember that the major issue has been that of how to fund the system. The interim committee, which met for 3 years, wrestled with the funding issue as well as how the system would be structured. Even the Idaho Association of Counties has a divergence of opinion on how the system should be structured. The interim committee has been quite adamant that the system maintain its local control aspect and not go to either a statewide or regional system. With 44 counties operating independently, except for 2 joint county offices, it is not easy to make changes quickly. The interim committee was also quite concerned about standards. There was a lot of discussion about standards and how they should apply to Idaho. It was felt that the standards should be Idaho standards and not just use national or other standards. The committee wanted the standards to be applicable to Idaho. With this in mind, the Public Defense Commission has requested funding through an object transfer in this year's budget to conduct a study of workload in Idaho. The terms caseload and workload are not the same. In the view of the Commission, workload is a better term to use a caseload that has too much variability in it. After passage of House Bill 504 in last year's legislative session, the Commission has been working on the standard rules. It was the Commission's view that negotiated rulemaking would be the best in creating these rules. That process was followed, as you can see in the rules, with 7 meetings held throughout the state. It was after those meetings that the national standards, which were originally included in the rules, were removed. I want to thank you for consideration of this rule and request that it be approved so that we can move forward and complete the workload study and provide standards that are truly Idaho standards. Thank you on behalf of Chair Bowles. Defer to the committee.
Thank you, Ms. Simmons. Are there any questions for Ms. Simmons? Representative Luker.
Thank you, Mr. Chairman. And Ms. Simmons, since we've got you here, I'd like to follow up on a question about the incorporation language.